Excuse me. And we'll begin the afternoon with emerging legal issues and ways to deal with them, with the panelists comprising of Harry Callicotte, the managing member of the law firm of Harry D. Callicotte, PLLC. From 2008 through 2014, he served as the senior corporate counsel in a Magnum Hunter production in Lexington, Kentucky. Has over 32 years of legal and business experience, primarily in the energy sector. Harry is admitted to the practice before the Kentucky bar as well as both Kansas and Missouri. He's also a registered professional engineer and 30-year member of the Society of Petroleum Engineers. Has a BS in petroleum engineering from the University of Kansas, an MBA in management from the University of Texas, and a JD from the University of Missouri, Kansas City School of Law. Also on our panel, we're happy to have Karen Greenwell. For those of you all who know, Karen is the chairperson of COGA's legal committee, which has been doing some outstanding work and providing some significant help to the organization over the last year since that committee has been reconstituted. And Karen, with over 25 years of legal experience in the mineral and energy industry, she's assisted on oil, gas, coal, and energy clients with all manners of transactions, including leasing matters, asset acquisitions, divestitures, corporate mergers, and stock acquisitions, bankruptcy sales. Her experience in litigating property and mineral-related contract and business tort disputes, as well as in other types of commercial litigation, gives her an unusual breadth of experience and perspective in dealing with issues affecting mineral and energy industry clients. She is a trustee of the Energy and Mineral Law Foundations, a member, of course, of the Kentucky Oil and Gas Association, and is on the advisory board of the Institute for Energy Law. She's also an adjunct professor at the University of Kentucky College of Law, teaching courses in mineral and energy law and policy. And our third panelist, also a COGA board member, J. Kevin West. With over 25 years of experience, Kevin West's practice has been focused on the energy industry, both as an outside and in-house counsel. His practice includes complex litigation, asset and stock transactions, lease transactions, and land and legal due diligence for acquisitions. He has managed the government affairs process and drafted legislation regarding natural gas operations. And one thing that I'd like to add prior to going into the panel is I made reference, we've had over the last year the reconstitution of the COGA Legal Committee. Some of that was, I'd say not just some, but was largely motivated by recognizing the increasing legal issues that have been facing the industry and the role that COGA needed to play in promoting the industry's position and ensuring that we were being heard in that process. Some of the cases I'm sure that you will hear about now through the panel, but over the last year to 18 months, COGA has raised and spent over $40,000 in filing briefs, amicus briefs in the Court of Appeals level and the state Supreme Court level. And so certainly appreciate the support from our members and the companies who have contributed to our legal fund in the past. But just again, this is the role that the association should serve its members and the industry represents. And it's a facet of the association that we're going to continue to focus on and ensure that as these continuing litigation battles unfold in front of us, that the industry is being represented and COGA is going to be the voice in that. So with that, who's going first? Karen, are you going? Kevin? Yep, Kevin. Kevin West. On the slide? I think it should. I think they got things pretty well coordinated.
Oh, okay.
Change the order on us.
Oh.
Do you all want to go through your presentation, then full Q&A at the end?
That's not, that's the wrong one. Yeah.
All right, I think I figured out how to use the clicker. I'm Kevin West. I was elected to go first, which I'm glad to do, although it puts me in the unenviable position with my esteemed colleagues here. I kind of feel like Tiny Tim warming up for the Beatles and the Rolling Stones, but I'll do the best I can. And I notice many of you out there in the audience that have a lot of knowledge about the issues we're going to be talking about, and I think Andrew said we're going to have a Q&A at the end and would welcome everyone's participation. Also going to welcome, during the course of my presentation, Harry and Karen both have been very involved in following the Bluegrass Pipeline case, so they may have comments that they want to provide as we go through there. As far as the topics we're going to talk about, we're going to kind of go what might be considered backwards as far as if you're looking at from the wellhead downstream or upstream. I'm going to talk about an issue that is primarily related to gas transportation. Harry's going to talk about post-production expenses, so the gas after it comes out of the well and how you treat royalty, and then Karen's got an assortment of things, some of them including topics with regard to leasing. So hopefully we're giving you a good spectrum of issues with regard to legal issues going on in Kentucky with regard to oil and gas. But if we have time at the end, to the extent you have other issues you want to talk about, we'll do our best. And as I've already noted, we've got some very esteemed legal minds in the audience and would welcome their participation in helping out. So Bluegrass Pipeline, I don't know, I think a lot of folks, certainly those that are active here in Kentucky, are familiar with the case. It's a case with regard to the exercise of eminent domain by, in this particular case, a gas transportation company. As we talk about the Kentucky statute, it can be interpreted as being broader than just applying to those involved in gas transportation or gas gathering operations, but we'll kind of compare and contrast it to some of the states that surround Kentucky. But eminent domain, I think most of us, even folks not involved in the oil and gas industry, have some concept of what it is. Everyone's familiar with the highway department having to condemn a piece of property in order to form a highway. And there are instances in most states across the country that give certain folks involved in the gas transportation business the ability, if they cannot reach an agreement with a landowner, to use a statutory mechanism to acquire the property for a right-of-way needed for, in this particular instance, a gas pipeline. I think there's a common misconception in the public, and sometimes it's created, I think, by those that oppose eminent domain, that you're just going to take somebody's property away from them, and it doesn't work that way at all. They have to be justly compensated and paid the fair market value of their property if you engage in a condemnation proceeding. And certainly, as you probably realize, when we're talking about condemnation for or eminent domain for a natural gas pipeline, you're not talking about taking someone's entire property. You're need to use a very small portion of it in order to construct your pipeline and maintain your pipeline. So, as I said, in most of the states in the Appalachian Basin and the states that surround Kentucky, there are opportunities for those involved in the natural gas business to use eminent domain, if necessary, to acquire property necessary for gas transportation operations. There are varying degrees on the scope of that and how it can be used. Pennsylvania has a very limited availability. It just applies for regulated entities. There was an interesting series of cases, the Laser and the Peregrine cases, for those of you familiar with Pennsylvania, a couple years ago, in which there was a gathering company that said, hey, we would really like to have this eminent domain, so what we're going to do is we're going to file an application with the Pennsylvania PSC, and we're glad to say, hey, we'll be a regulated entity. As you might imagine, the other folks involved in natural gas transportation, the midstream companies in Pennsylvania, said, hey, wait a minute, be careful what you ask for. Do we really want to subject ourselves to the full regulatory scope of the Pennsylvania Public Service Commission, including our rates? And so after their application had been approved, it was withdrawn because of the firestorm that occurred with regard to that. So all that to say, Pennsylvania has fairly limited ability to use eminent domain in midstream proceedings, except for public utilities. Same is true in West Virginia. For the most part, it's only applicable to FERC projects. Indiana, public use is the triggering words. Illinois, public property. Ohio has a fairly expansive statute with regard to eminent domain. It affords the ability to use eminent domain to any company engaged in transporting natural or artificial gas or petroleum products. It's not been used frequently in Ohio, but the statute is fairly expansive. Kentucky, quite frankly, after over the course of the last couple of decades, have an opportunity to review several of these statutes in the Appalachian Basin. I always believed that Kentucky had the most expansive. If you look at the statute, the granting statute in Kentucky, it arguably applies not to just natural gas transportation, but to natural gas production. So that arguments could be made, in effect, that you could even utilize the statute with regard to having to get access to a well line, although in most instances, you've got lease rights to do that anyway. But just looking at the statute and reading the statute, it's probably, without a doubt, the most expansive statute in the Appalachian Basin. And it was interpreted that way for decades. And there was really never any question, I don't think, that anyone had that, for instance, for a gathering line, that if it was necessary, if you made the effort to try to acquire the right-of-way you needed to construct a pipeline and couldn't do it, that you would be able to fall back on Kentucky's eminent domain statute. Several cases over the past few decades interpreted the statute. The most recent was a Kentucky Court of Appeal case called Milam, and it involved the condemnation or the use of eminent domain to get a right-of-way to transport gas from a well site to a transportation line, basically a gathering line, and approve the practice of using eminent domain for that reason. The EQT gathering case was a federal case, United States District Court for the Eastern District of Kentucky, applying Kentucky law. And in that particular instance, the court said, yeah, EQT gathering has the right to use the eminent domain statute because they're engaged in transporting gas for public use. Now, the lines involved that were going to be constructed, none of them had lines going off where public utilities were necessarily going to be using them, but the court hit upon the fact that, hey, you're transporting not only your own gas, but third-party gas on this line for other producers. So because you're doing that, that's use in public service, and you're entitled to the use of the eminent domain statute. For instance, I was involved too in those of you familiar with the Big Sandy pipeline. We actually used the Kentucky eminent domain statute, although the condemnation action was filed in federal court and it was a FERC-regulated pipeline. But to the extent that we weren't able to acquire properties, mostly because of unknown and unlocatable parties, we fell back upon the Kentucky statute because it was actually broader than the rights that we would have had under the Natural Gas Act. The final case there is the oldest of the cases, which was a Kentucky Supreme Court case where condemnation was approved with regard to an oil pipeline. Over the course of the years, producers and folks involved in the midstream business in Kentucky have known that they could use the statute. So technically, what do I mean by technical reliance? They knew they could rely upon it if they needed it. And certainly it was a tool in the toolbox when you went out and had to deal with a landowner and were trying to negotiate and just had someone that was unreasonable, or if you got a situation that economically you knew that it was going to cost you a lot of money to go around a track that had a lot of unknowns and unlocatables, you knew you could fall back upon it and use it. I think that what we have seen, though, it's not been used as a sledgehammer traditionally by folks involved in midstream business in Kentucky. So there was always a conservative application of it. It was the last resort. And, it was not something that was really used all that frequently. But everyone, I think, relied upon the fact that if they got into the situation they had to, they could use it. So what changed? What happened? Was this expansive statute modified in some way? Well, no, it wasn't. I mean, there were efforts at that in the General Assembly. I guess it was in, was it 2013? The 2013 session, where there were groups who were the same groups that opposed the Bluegrass Pipeline, who made some efforts to change the statute, but that wasn't done, thanks in large part to the yeoman efforts of the Governmental Affairs Committee for COGA, who was very actively involved in that process. But what did change is what I would say was kind of a perfect storm. With regard to the scope, the location, and the timing of this Bluegrass Pipeline project. The project was a natural gas liquids project, a pipeline, which was going to go through an area of the state in central Kentucky where there had traditionally not been a lot of oil and gas development. Those of you who are here are probably here because you're familiar with all the developments gone on in western and eastern Kentucky, and that's not something that folks in central Kentucky with horse farms, or particularly if you're going through property owned by the Sisters of Nazareth, that they're accustomed to. So you had this where the industry was going to be involved in a location of the state where they weren't traditionally involved. You had the fact that it was for a natural gas liquids, something else folks were not very familiar with. And it was a situation where these were not liquids being produced in Kentucky, and they were not liquids that were going to be used in Kentucky. So I think as far as Bluegrass Pipeline and where we ultimately wound up with that, or where we are right now, hopefully temporarily, that had a lot to do with it. And then just the timing of it. As all of you involved in this business are aware, there's been a lot of lashback at the business with regard to issues raised by landowners groups, environmental groups, that sort of thing. We're going to have some discussion of that later in this afternoon on one of the next panels, but all those things kind of came together. So as a result of that, you had this lawsuit filed by this group that was against eminent domain in Kentucky. And they filed the lawsuit in the Franklin Circuit Court, which is a court that typically has not dealt with oil and gas issues. Those of you that are involved in the legal community in Kentucky are well aware. And they filed this lawsuit where they alleged that the Kentucky statute was not expansive enough to allow condemnation by the Bluegrass Pipeline. So the trial court, there were issues raised. Do these folks even have standing to file this lawsuit, as the facts were that the lead plaintiff in the case had been approached at one point. There had been a conversation between Bluegrass Pipeline and the lead plaintiff, but that this plaintiff, his property never really even became part of what the route was going to be. The trial court on the standing issue ruled that they did have standing, and basically adopted in that PSC staff that should be not to or for the public, but adopted the PSC staff's interpretation that eminent domain should not be allowed to the Bluegrass Pipeline because it was not in public service, since it was transporting natural gas liquids through Kentucky. There were NGLs were not being produced in Kentucky, or were they being used in Kentucky. It's a 500-mile natural gas pipeline for the transporting NGLs across the state. I'd already mentioned that. And so the trial court ultimately ruled that these folks had standing, and that under Kentucky's eminent domain statute, Bluegrass Pipeline could not use the eminent domain statute in order to acquire right-of-way. So the case was briefed. Well, after that decision occurred in the trial court in the Franklin Circuit Court, there was an appeal taken by Bluegrass Pipeline to the Kentucky Court of Appeals. That issue was briefed. COGA filed an amicus brief in the proceeding. I actually went to the oral argument. There were at least one of the judges that I knew probably weren't going to go for us. There was another who I thought was kind of on the fence, and you couldn't tell one way or the other which they were going to go. And then there was a third who I thought definitely was going to rule that the decision of the Franklin Circuit Court should be reversed. Well, my prognostication was not correct, and in a 3-0 decision at the end of May, the Kentucky Court of Appeals affirmed the decision of the Franklin Circuit Court. The court held that negotiation was enough to confer standing. Associational standing was appropriate because a member was approached. As I had mentioned, although the right had changed, the court found that citizens have the right to challenge the wrongful exercise of government power. And then ultimately, the court held that it agreed with the trial court that this was not, because this was not a project that was in public service, not regulated by the Kentucky PSC, and NGLs not reaching Kentucky consumers, that the trial court decision should be affirmed. The thing I think that it is important, and we'll talk about this in just a moment, and then I'll wrap up because I don't want to take too much time away from my colleagues, but the court really focused on that not regulated by the Kentucky PSC portion. The trial court decision was a little more expansive than that, but that was kind of what the Kentucky Court of Appeals honed in on. So what's next? And I'm going to wrap up so we can move on to post-production expenses. A motion for discretionary review has been filed in the Kentucky Supreme Court by Bluegrass Pipeline. We have no real guess as to when the Kentucky Supreme Court will decide whether or not it will take this issue. It's the type of issue that if you follow the discretionary review rule to its letter, that would seem to be the type of case that the Kentucky Supreme Court should accept, but we'll find out. If they do accept the issue, then what will occur after that will be briefing similar to what went on in the Kentucky Court of Appeals. Those of you that operate in Kentucky are familiar with the Farm Tap Statute, KRS 278.485, which says that if you're within a half air mile, if you're operating a pipeline or a well within a half mile, anyone within a half mile of that facility has the right to get access to be provided with farm tap gas pursuant to tariffs which are regulated by the Kentucky PSC. There's an argument that can be made that if you look at the letter of this Kentucky Court of Appeals decision, that folks involved in gathering of Kentucky gas could certainly make an argument that they fell within that, and that they could distinguish themselves from the Bluegrass Pipeline. And then just, when you're drafting your leases, precise drafting as far as making sure you do have the rights to transport gas produced from other leasehold tracts across the leasehold tract that you're leasing at that time. So with that, I will turn things over to Harry, who's going to talk about post-production expenses.
And Kevin, you would have probably felt better if your three-judge panel had been this panel right here.
so.
Yeah. Unfortunately, you were in the People's Republic of Franklin County. Anyway, let's talk about leasing and where leasing can get you in trouble, especially if you're still using that old Producers 88. Just by a show of hands, operators in the room, is anybody still out there using that old 88 form? That's okay, don't be embarrassed. I've used it. So we still use it in Kansas. Anyway, what are post-production costs? Some of the things up here you'll see, gathering, separating mostly really a production cost, but in some instances can also be a post-production cost. Storing, which is not really as relevant. Dehydration, if you're talking about just the separation of water, that's usually a production cost, but if you're talking about the dehydration of the pipeline, that's different. That's going to be a post-production cost. And then, of course, the ones that are more familiar to us, compression, which is simply getting the gas down the line by pressuring up the gas because it moves from a higher pressure to low pressure in a pipeline. Transportation, which pretty much is everything in the line. Processing, for example, taking out the natural gas liquids. And oh, by the way, it's all natural gas. I don't know if that ever came up in that Bluegrass Pipeline case, but I guess the laws of physical science apply universally except in Franklin County. So hopefully nobody here is from Franklin County. So. And then, of course, treating and marketing and all the way down the line. Basically, any other costs or all costs and expenses that occur between the wellhead and the point of sale. So we get into this thing where we have to calculate the royalties, which for crude oil, it's simple. The purchaser comes in there, they pick it up, they send out division orders, they do all the accounting for you. My personal favorite, of course, is crude oil because you don't have to punch the calculator as much. A little bit more tricky with natural gas. But common lease terms that you'll see are things like market price at the well, proceeds at the well, market value at the well. In other words, at the well, just exactly right out of the old Producers 88 form. So how do you determine that price or the proceeds at the well? Because you're certainly not going to be selling the gas at the well. That's very rare. The natural gas is going to be sold somewhere further down the line. So there's two theories out there that occur. There's the marketable product rule, which is where you have to make the natural gas marketable, because the raw gas, unless you're getting almost 97% methane coming out of that well, almost always that gas is going to have to be treated and processed in some way. So you have to make that natural gas marketable, i.e. enough to go into the interstate pipeline system. Or whether or not you can net back the price, which is the at the well theory. States that follow the at the well rule, which is a majority, it's a majority rule, are all those states you see listed there. A lot of them the major producers, Texas, California, which is a very significant producer, North Dakota, of course, which is now, I believe it's the third largest producer of oil in the country. and New Mexico, which is a significant producer, and of course Louisiana, where you get a lot of associated gas. And now Pennsylvania, where it's not a question, it's actually statutory. But Texas was a recent case that came out of Texas just last month out of the Texas Supreme Court. It's a Hyder case, something for the folks that have any interests or operations in Texas to keep an eye on. Fortunately, this only involved an overriding royalty. So as far as the royalty expenses are concerned, they're still at the well or follow the at the well rule. And also in that case, there was actually specific language in the lease too that said that it would be free of costs. So there's a little bit extenuating circumstances there, but again, something to keep your eye on because it was a change in the Texas string of case law. States that currently follow the marketable product rule, I believe as long as Owen Anderson is alive and teaching at the University of Oklahoma, they will always follow the marketable product rule. Arkansas, now Kansas, this is a case I actually had a pecuniary interest in, meaning I didn't do the legal work, I had to pay for the legal work. That case, Oil Producers, Inc. of Kansas, just came out of the Supreme Court, and a really interesting shift in the state of Kansas where the post-production and post-sale processing expenses deducted by third-party purchasers are shared. So that's actually a twist on the marketable product rule, a very significant twist. And then in Virginia, there's really no case law that I know of. I don't know if any of my colleagues or our colleagues are here from Virginia. There is a federal case in Virginia, I didn't have the site there for you, where it says that Virginia follows the marketable product rule, but there's also an Attorney General opinion regarding force pooling where it says that the deductions or post-production deductions could be taken from a force pool royalty. So there's a diversion there, or excuse me, a diverting there. And then of course, West Virginia. I call it the super minority. The class of one, the Tawney decision, which by the way, was a case that wasn't even tried, which is really interesting because West Virginia, there's no court of appeals in between. You go straight to the Supreme Court of the state. I'm not sure if any of our West Virginia colleagues are in here, but they could certainly tell you about the pitfalls of going directly from a trial court up to the Supreme Court. Now, why would there be a marketable product rule in a place like Oklahoma or Kansas? Well, take a look at the pipelines. When I used to operate in Kansas, you couldn't throw a rock without hitting an interstate pipeline. So getting the natural gas to a pipeline was almost, you could almost see it from where you were operating. It was not that great of a deal. A little bit of compression and you got it in line. The cost not that significant. But take a look at Kentucky. If you're operating, say, in southeastern Kentucky, like Harlan County, which is in the corner down there, you got to go quite a ways to get to an interstate pipeline. And if you're producing low-pressure gas, you're going to have to compress it all along the way. If you have a high BTU value of lots of liquids in your gas, you're going to have to get those liquids out because the interstate pipeline's not going to take it. They're going to want those liquids stripped out of there. So all of these costs are significant when you get into places like Kentucky or anywhere that's where you have high liquids in your gas and you're far away from interstate pipeline system. And then some of the states are still undecided. I threw Tennessee in there, not necessarily a significant producer of natural gas, but just something to be aware of if you're producing in Tennessee, that nobody's challenged us so far. And trust me, I guess it would be the oil and gas version of ambulance chasers. There's people out there that are looking for a forum. And you'll see how they forum shopped in Kentucky, for example. Same group of plaintiffs' lawyers.